Good morning, friends. Sat Sri Akal, Adab. Once again, I am back. I don't know whether you are understanding the word old grant, whether these definitions are hackling your mind. Now, this is the second type of grant. This is now that grant of 1895, Grant Act 15. Defined that when the terms and conditions of above grant were not forthcoming, and in that case, would the conditions of occupation of rights in the land would deem to be held under TPA Act 1882. It is reproduced in Rule 43 of CLA also. The analogy of that government need not be in possession of the grant document is therefore flawed as the very condition under TPA Act 1882 would then be overturned when there was no evidential document forthcoming in the conditions of the grant. So what is the document which forthcomes? Is a cyclostyle document of 1836 GGO 179. So by that only the government or the judiciary or the law has been interpreted in such a form that we fall under the Grant Act. No, we don't. Because our grant, even GGO 179, had to be registered. So now the question comes whether regulation territories, having become purely British territories, where the sovereignty was totally acquired by the Britishers or of the Indian rulers, will the GGO be applicable there only? I'll read a small cutout from the Ambala Gazetteer, which said that Ambala was a new municipality in 1862. Ambala Cantt, as reproduced even in the bylaws of 1937, that when transfer of assets from municipality under section 30, we had only the assets being transferred, no land was transferred. So this was for the House Accommodation Act area as civil private areas. Why were we called the civil municipality of 1862? There were no boundary pillars for the Ambala Cantonment. So you have to take out your gazetteers. Please, I have requested Gopal Narayanji when he was alive. I have requested a lot of bungalow owners like Mr. Zaki, who is no more, Mr. Bhojwani, who is no more. Please dig in your cantonment gazetteers from Pune to Sikandrabad, Barrackpur or Allahabad, Ranikhet, Lansdowne. These gazetteers are somewhere lying. Just dig them out. Now, what does Punjab Land Manual says? It again defines grant of land revenue by the state to a private individual are often compendiously described as Jagirs or Mufifs. No broad distinction can be drawn between the two terms. Jagir is usually appropriated to the larger grant and exceptionally to those given for services of a military or official character, and Mufias to assignments of less value and importance. The subject is one of the most which is kind of considered in Punjab. Most of the grants come under like this. So what does Punjab Administration Report speaks in August 1852? Again it reimbibes the doing of 1765. The revenue-free assignments or cash pensions which had been enjoyed under the Sikh government were classified as what? 1. Service grants, which could be subdivided as military, civil, feudal or household. The second was the personal grants, which were in the form of subheads as pensioners, royal ladies, family provisions and allowances to some influential people. And the third culmination of the grant was called the religious grants. These were endowments given to societies, charitable institutions and holy men. So now the treatment to all these three types of grants was different. They were dealt in a very different way because of their classes. For those grants which in cash or in land are allowed in consideration for long services, as these rules were adopted, were given. The beginning was from 12 years to 25 years. went up till 30 years, and 1/4 of the emolument was to be given back. Then came a period which was much bigger, that was 30-35 years. There from 1/4 it came to 1/3. Another 35 to 40, the emoluments reduced further on to 1/2, and till the built up period of the grant. So everywhere if we were seeing, these grants were subjected to some kind of lagan which was to be given back to the ruler. So these were the original Akbari system grants, and there were smaller grants which actually diminished between 25 to 30 years, or maybe maximum 15 years. These were called the Jagirdaris. Now I'll talk of the Sindh Satluj state Jagirdaris, which is very peculiar. This entire area between Jamuna and Satluj was better known than Sindh Satluj state. About 38 to 42 petty rulers came into it. Mr. Kingston has very clearly in Ambala Gazetteer reproduced the following paras. I am reproducing the Gazetteer. It again talks of Regulation 31 and 36 of 1803, where the original royal grants or the Badshai grants were considered to be ceded to the province if the ruler or the native rule was acceded to the British. No, it didn't happen like this. It simply said these royal grants were kept in place, and the original grant given by the native ruler was heritable by the grantee. So these assignments were confirmed by the Britishers as written by Mr. Kingston. 1882 Gazetteer. Now the theory of revenue free grants again came back. Again it came back to the hereditary system, or the grant in perpetuity was first used here in 1865. That are these grants in perpetuity? I remember an advocate from Ambala talking to me. He had won his resumption notice, where he had said that these grants are in perpetuity, whether you are a lease in perpetuity or you are a grant in perpetuity. Maybe he must have read this in the Ambala Gazetteer. So these heritable grants were transferable. They were either given by gift or by sale. Heredity itself means that under the Inheritance Act they could be taken from father to son, son to grandson. So grants were for continuity, and they were revenue free grants. Now what does the Punjab Settlement Manual says? Here it defines occupancy rights. So what are now occupancy? Now what did I say Lord William Bentinck had said on 26 September 1832 in the book? I have little hesitation in declaring my conviction that there is very generally all over India as description of riayats having a proprietary title in the lands cultivated by them. These riayats are termed Mirsadars, Mirasi, Morosi, Khudkhast, Khadim. These were some words at those days of the Muslims being used. Lord William itself said, he remarked, always be borne in mind that though there may be cultivators who have proprietary rights of occupancy, it does not follow that all cultivators have such rights, and the greatest care should be taken to avoid confounding. When the hereditary riayat whose ancestor perhaps first broke or tilled the soil and paid the revenue or rent of that land direct to the servant or to the state is called the original grantee. Now here he is saying that maybe my original old grantee was somebody else, but because in the passage of time the hereditary grant did not transfer because it came in my hands, I have been in occupation for 25 years or 35 years or 45 years and have been paying that produce. So I am the old grant. But originally these grants were revenue free grants. I hope, friends, I am able to explain myself. Any questions, I will appreciate. Get back to me. Thank you. Good day. Can you